Good morning. Thank you, Martin, for inviting me. I would like to make some comparative remarks on the role and destiny of constitutional courts in some countries which have experienced in the last years a constitutional deterioration or degeneration. These are two kinds of countries. Hungary and Poland, for example, they had an apparent consolidation of democracy, while others, Russia, Turkey, and Venezuela, these are the cases I consider. In these three countries, there already was an authoritarian degeneration, an authoritarian system which suffered in the last years a further deterioration. So I consider these two types of countries. And in both cases, the courts were heavily implied in authoritarian degeneration and in maintaining the status quo, being either assaulted or manipulated. And in examining the way in which this regression impacted the courts, I will try to underline the role and responsibility during the regression, since they were either victims or collaborators of that regression, and after it. These countries are labeled under the umbrella term of populism or sovereignism, even though I do prefer to talk about constitutional regression or devolution, meaning a modification, amendment, or replacement of the constitution, or its emptying or derogation in order to neutralize the system of checks and balances. The implication of constitutional courts in such regressions depends on several causes, especially the will of the dominant party in a given historical moment, but also to mistakes made by previous legislators or constitutional framers, as was the case in Hungary and Poland. In some of the cases examined, the constitutional courts which played a prominent role in the past and turned against the majority will, ruling majorities, suffered a drastic reduction of competencies or maybe through the supply of the loyalist judges. This was the case in Hungary and Turkey. Consequently, I distinguish between the countries in which illiberal rulers had a sanctioning attitude towards constitutional courts. This is the case of Hungary, Poland, and Turkey, and others where they try to subdue the courts regardless of their previous behavior. Such was the case in Russia and Venezuela. I focused my attention on some aspects, for example, the way in which the degeneration occurred through the modification or derogation of the constitution, the role of the courts in such regressions, and after the regression, and also the responsibility of supranational stakeholders or actors. Some of the countries analyzed important democratic phases in their past. This is especially the case of Hungary and Poland, in which until from 1989 to 2010 to 2015 respectively, there was a consolidation of democracy. Venezuela also was considered among the most stable Latin American countries after 1958 until the end of 1980s. While in the case of Russia and Turkey, I consider they have in their genetic code authoritarian elements, which are, I would say, permanent. All these countries have been submitted to democratic conditionality of regional organization for the protection of human rights. Thank you, Martin. And in the case of Hungary and Poland, also to the complex path of democratic conditionality that precedes the entry in the European Union. And notwithstanding the many differences between these five countries, there are many similarities in the efforts of political rulers, ruling parties to atrophy judicial counterweights. This was the case in Poland, Hungary, and Turkey, or vice versa, to make the courts their greater support in the nationalist project to rebuild the society. This is the case of Russia and Venezuela. In the long term, after their neutralization, the courts became submissive and therefore supportive to political leadership, Although I consider that in Poland and Hungary there is still glimmers of positive evolution, at least with reference to ordinary courts. Another element I consider this is the political implication also depends on the competencies of the courts, because in Turkey and Hungary they were very wide with a potential political impact. I would give you some examples of judicial decision of the five very briefly. For example, in Venezuela, I considered two decisions of January 1999 with an ambiguous content of the Supreme Court of the time that favored the constitutional transformation, because the Supreme Court allowed the holding of a consultative referendum for the convocation of a national constituent assembly, which was not provided for by the current constitution at the time. And the court was replaced in the new Bolivarian constitution with a Supreme Court of Justice as a new apical court, top court, to be elected by the new political majority. And this new court suddenly became a reliable instrument of regime. For example, a series of decisions starting in 2003 denied the superiority of international treaties on human rights despite the provisions of the Constitution. And since the end of 2015, numerous decisions have been adopted to support the President to challenge the authority of the newly elected National Assembly, in which the opposition party got the majority of votes in December 2015. In Turkey, Constitutional Court has played an important role in terms of democratization, Europeanization, and especially secularization since the 1960s, when the court was introduced, was inspired by European models, and it managed to gain credibility nationally and international as an important barrier, especially in the secular direction. But over time, the court compromised the interest of the ruling majority, which in different moments reduced its autonomy and the competencies of the court, in particular following some judgments of 2007-2008, which affected important political interests of the Justice and Development Party, IKP. And especially with the constitutional revision of 2010, the number of constitutional judges increased and the role of the head of state in their designation also increased. And further minor changes were introduced with the constitutional amendment of 2017. The Russian case is quite slightly different, because this court has never been so powerful or authoritative since its creation in 1991. But due to its political involvement in a very critical moment in 1991 to 1993, the Russian Constitution of 1993 reduced its responsibility, and after that there has been no major changes in the composition or competencies of the court, although the change of the method of appointment of the President and Vice President in 2009 represented an evident reduction of its autonomy. But this court, unlike the others that I have examined, have not given evidence of insubordination to the executive, because it legitimized the war in Chechnya, incorporation of Crimea, favored the contraposition with the Court of Strasbourg in politically sensitive issues, and so on. Hungary and Poland. Political pressure on constitutional judges is particularly unbearable in these two cases, because these countries have passed a long and difficult process of constitutional transformation from the communist system. And especially in the Hungarian case, the courts played a relevant role in dismantling the remnants of the previous political regime and in the democratization process. The Polish Constitutional Tribunal was even introduced at the end of the regime. The Hungarian court was introduced in 1989, but soon became an important counterweight on the political scene, adopting many counter-majoritarian or anti-majority decisions. And they were very, they had a high prestige and also authoritativeness in these two countries. And when Fidesz MPs respectively come to power, they influenced the appointment of constitutional judges, they paralyze the courts or make them submissive, introducing manipulable judges close to the ruling majority. These are very well-known cases. In both cases, the courts tried to resist, but the parliament, for example in Hungary, constitutionalized legislative provisions which the court declared unconstitutional. And apparently Poland followed the same path of Hungary, but in the absence of a political and constitutional majority, the Conservative Party acted differently by violating the Constitutional Tribunal judgments many times, and therefore the Constitution. Also, this tribunal tried to resist, but after the replacement of the constitutional judges, there is a paralysis or neutralization of this institution. What is happening after the regression to these courts? They survived with the aim of strengthening political consensus. For example, with they legitimate constitutional regressions, elaborating their own theory of constitutional identity. This is especially the case of Russia, Hungary, and Venezuela. Even though in the first two cases the content of this identity has not been clarified except with reference to very vague values or generic principles, whereas in the case of Venezuela it has an ideological content with a clear populist nature. I refer for the Russian court to some judgments very well known, Markin in 2013, Anchugov and Glankov 2016, and Yukos 2017. As for the Venezuelan Sala Constitucional, was very rough, more crude, particularly in trade decision 2008, 11, and 15. In the Gustavo Alvarez Arias case, the Sala Constitucional theorized the subordination of law to politics, and saying that the standards to settle the conflict between principles and norms must be compatible with the political project of the Constitution, that is, Estado Democrático y Social de Derecho y de Justicia. As for Hungary, there is a very famous decision of November 30 of November 2016, in which the court did not clarify what constitutional identity is, referring to that principle and to the concept of historical constitution. Despite all this sub-picture, I can say that the role of the courts nowadays after the regression in this legal system is not completely negative, and they have another role going beyond the simple legitimation of the regime. This is my opinion. In Russia, for example, Constitutional Court focuses on specific issues which are relevant to citizens' economic and social rights, and in these cases, for some aspects, the Constitutional Court continues to refer or to align with the ECTHR case law. And as for the case of Turkey, for example, there was the introduction of the individual petition procedure in 2010, starting operating in 2012, and since then the court pronounced several relevant decisions going against the interest of the ruling party in many cases, for example, defending YouTube and Twitter suspension, protecting the environment, freedom of expression of journalists, and so on. And in making some concluding reflection, the 5 countries examined, I distinguished 3 cases as for the incidence of the degeneration on the constitution. For example, in the case of Venezuela and Hungary, there was the adoption of a new constitution. In other cases, in Turkey and Hungary, the adoption of amendment of the constitution. In the case of Poland and Russia, the derogation and the emptying of the constitution in force. Degeneration occurred through 3 phases: the replacement of judges, Hungary, Poland, Turkey, and Venezuela; reduction of competencies, Hungary, Turkey, and directly Russia in the past; the making it more difficult to take decisions in Poland. The behavior of the court, I distinguished the court with favored degeneration. This is especially the case of Venezuela. Supported it with the doctrine of constitutional identity or similar, Russia, Hungary, or suffered it in Turkey. And after the regressions, in some cases their support is total and rough. This is Venezuela again. In others, almost total, since they support the rulers in politically sensitive cases, Turkey, Russia, and Hungary, while have greater autonomy in individual cases or aspects, dissenting opinions, social rights, other rights. In Poland, for the moment, the Constitutional Tribunal became quite passive. So I will stop here. If you have any question, I will resume other consideration. Thank you very much.